coming here this morning. Hopefully our volume is going to be high enough and not too loud for your cameras. And we're going to hope that we don't get a lot of that. So this morning at 9:30 a.m., I delivered to Governor Lee's representative our request to pause all executions in the state of Tennessee until after the opportunity for the federal court, or for the Chancery Court to conduct its review of the new lethal injection protocol. This afternoon, or this morning, we'll have some speakers here today to talk with you about their concerns as well. Oscar Smith's longtime personal attorney, Amy Harwell, will talk with you about what it's been like for Oscar as he faces an execution just 6 weeks away. Rafia Muhammad McCormick, who is a victim advocate and founder of Rodney's Place, will share with you her perspective on what's going on in Tennessee with respect to executions, particularly in light of the fact that we've learned from reporting done by the Tennessean that the state of Tennessee has spent nearly $600,000, an astonishing amount of money, on these chemicals. You'll hear from Stacey Rector, the Executive Director of the Tennesseans for Alternatives to the Death Penalty, to provide a community perspective of what's going on here in Tennessee. And then finally, Kevin Riggs, who is a spiritual advisor to many of the men on Tennessee's death row, and who works very closely and is a co-author of a book with our lead plaintiff in the case, Kevin Burns, will share with you a faith perspective of the concerns that we have surrounding this new lethal injection protocol. But briefly, I would like to take you back in time to April 20th, 2022, which is what started the reason why we are here today. That afternoon, I was sitting in my office, convinced that our client, Oscar Smith, would be executed 24 hours later, knowing in my heart of hearts that the department had not followed the protocol that they said they would follow, knowing in my heart of hearts that they had not conducted the testing that they swore to every court that they had been in front of that they would do. And so I said, I'm going to send them an email. I'm going to make a record because this is going to come back. And so I sent an email, and I copied the governor's legal counsel at the time, Jonathan Skrmetti, who's our new attorney general. And what we now know is a few hours later, on April the 20th, at about 7:30, based on a text message provided to us from the governor's office back at the time, they knew the testing hadn't happened. And they were still preparing to execute Oscar anyway. And they didn't tell us. The next day, they continued their preparations. They pulled the drug out of the refrigerator. They prepared the syringes to inject into my client. Laughing emails sent back and forth. Hey, I'm stopping at the store. Is there anything I can bring you? Hey, I'm not at the 12 o'clock meeting. I guess I didn't get an invite. And yet we know at 2:30 p.m. the drugs were prepared. At about 5:45, I sent a media advisory on the statement of my client's death. The statement on the death of Oscar Smith. It was the last thing I was going to do for him before I adjourned to conduct the vigil, the sad vigil we often do on dates of execution. 5 minutes later, I got a call from Samantha Max, who was with WPLN at the time, who said, hey, you want to revise your press release? The governor just issued a stay. I hooped and hollered and said, oh my God, what? I've got to go get Amy, who was at Riverbend preparing to take communion with Oscar. He was within an hour of his death, not knowing that the entire day there had been a tug of war over whether or not it was going to be okay to go ahead and execute him anyway, even though those drugs had not been tested in accordance with their promises to the court, with their testimony in depositions. Very, very quickly, we requested a preservation of all the evidence, and very quickly, the AG came to us and said, hey, you know that federal court litigation you got going on in the Millbrooks case? Would you mind pausing it? Because we need to have an investigation. We need to figure out what's going on here. So would you guys just stand down? It was appropriate for us to stand down. And it was appropriate for Governor Lee to do what he did next, which was to pause all executions and order an independent investigation to find out what was going on. By the end of 2022, we found out what was going on. TDOC had a culture of recklessness and non-compliance when it comes to executions. They did not care that they had lied to court. They did not care that the drugs had not been tested. And what we also learned is that my client, Donnie Johnson, who I watched be executed, who I heard sing the hymns, whose last words before the paralytic cut off his breath were, "No more dying there." Those drugs weren't potent. Those drugs failed testing, and they executed him anyway. And so the AG said, you know what, we need some more time. We need to figure out a new protocol. We need safeguards. And it was correct. They were correct. And the governor was correct to continue reprieves and pauses on executions while they figured out how to get it right. For 2 years since then, we've tried to get information. We've filed TPA requests. We've been stonewalled. We've been in a black box. We've had no idea what the department has been doing. But we've been trusting that they've been doing what the governor told them to do, put in more safeguards. Then comes December 27th, 2024, and the department says, hey, we've got a new protocol, but you can't see it. You can't get a copy of it. Just trust us, we've got it. Then you all did what you do, did what the Fourth Estate does, and you said, hey, that's not good enough. TPA exists. And on January 8th, they issued the protocol, a redacted copy of the protocol to the press, but not to us, just to the press. It was signed January 8th, not December 24th. We still don't know why. That protocol is a sham. It is a mere shadow of the previous protocol. The department was supposed to come up with more safeguards. Instead, they came up with less. The testing that was so important that the governor paused all executions in 2022 because they failed to do it has been eliminated from the new protocol. They haven't put in more safeguards. They've made it worse. It's riskier now. And this risk is not simply theoretical, folks. They make it seem as if a lethal injection is a medical procedure. It's not. It's poisoning. When they are being executed, you are watching poison being put into our clients' bodies. And science is clear on this matter. I've seen the autopsies. Our clients' lungs, the lining, is eaten away by the poison. Fluid flushes into their lungs, and for 18 to 20 minutes, they are drowning in their own fluids. But they can't be audible because the poisoning also cuts off the airway. It cuts off the airway, it cuts off the larynx. They can't let us know. They're tied down completely. So any movement is prohibited by the restraints. This is a serious concern. It's a concern so serious that our clients have actually said, we would rather be shot. We would rather have death by firearm than this death by poisoning. And that is what we have put in front of the Chancery Court. We have put our lawsuit in front of the Chancery Court. We went to court. We told the Chancellor, this is serious. We understand this litigation normally would take 4 to 5 years. We're willing to cut it by 75%. But we can't get it tried until January of 2026. The AG agreed. The AG was very worried about this expedited schedule. Everyone agrees we can't get it tried before then. But Oscar won't make it till then. Byron, he won't make it till then. And so what we're asking today is we're asking the governor to do the next right thing. We're asking him to pause all these executions. It's not his fault that the department failed in their obligations, that they failed to do what he directed them to do. But he can pause the executions and he can let the court do its job, let the judiciary do what it does, and we can do it in a way that is quick but protects everyone's rights. It's not our fault, it's not our client's fault that it took them 3 years to come up with a protocol that is less than half the length of the previous protocol. It is not our fault that they have eliminated the safeguards that they were directed to beef up in the protocol. We have acted as quickly as we can, and we think it's fair and just for the governor to give us a brief pause to let the judiciary move forward. And now I'd like to, at this time, invite Amy Harwell to the podium for her to share with you a little bit about Oscar.
Good morning. I'm Amy Harwell, an assistant federal public defender I, along with Catherine Dix, represent Oscar Smith, and I've been asked today to talk a little bit about what it was like on April 21st, 2022, as Oscar prepared to die. And to do that, I have to give you a little bit of context. And the context is that over the course of my life, I've taken communion a lot of times. I'm one of those people that as soon as my church said I was old enough, when I was 12 on Mother's Day, I got baptized, and I've taken communion almost every Sunday since. I'm not going to say there wasn't a Sunday here or there where I got sick and couldn't go, but almost every Sunday. But only once have I been allowed to take communion with one of my clients. And only once have I been allowed to take communion with someone who was scheduled to die. In the book of Matthew, Jesus tells us to visit the sick and the dying, to go see the prisoners. And I'm not going to start preaching. I'm a lawyer. We've got a preacher here. Pastor Riggs may do that. But it's important as we think about what happened in April 2022, as I try to tell you what that space was like, for you to know that even though I have been through many meaningful communion experiences, religion just doesn't get more real than communion in the death house. You see, in 2022, when his execution was scheduled, Oscar had gotten ready to die. He prepared himself. He asked us, his legal team, to take the money that he had earned and saved through the years at his job in the prison and buy a box for his body to be buried in. He called his family to say goodbye. He gave away his belongings. And he had a last meal with some of his friends on the row. He prayed and he tried to get his mind right. He got ready. And on the night that he was to be executed, Oscar took communion with his spiritual advisor. That is where we were. The spiritual advisor and I were sitting in a hallway with bars separating us from Oscar. But the spiritual advisor was blessing the bread and the wine, which were in little prepackaged cups to be safe in the prison, but passing it to Oscar. When suddenly the wardens appeared. And they were very polite, and it was a little awkward because they were both religious men and felt weird about interrupting communion, but they were there to say, sorry, execution's off. Spiritual advisor and Ms. Harwell have to leave the prison immediately. We were not told why. We were not told for how long. We were not told what was going on at all. I left Oscar not knowing if I would be let back in the prison in an hour, the next day, 2 days. It wasn't till later when Kelly picked me up and explained that the governor had issued a reprieve because the drugs had not been tested. And it is because TDOC violated its own protocol that Oscar has lived 3 more years. But he has lived those years with the imprint of the shadow of the death house. As you've heard, we're asking the governor for a reprieve because this new protocol doesn't even include the safeguards that they broke last time. It's as if, having been caught breaking their own rules, TDOC decided, let's just not have rules. We filed a lawsuit challenging this protocol, but Oscar's date is too soon. The court will not have a chance to adjudicate all the claims that we've brought. The court said the soonest this case can get to trial, even with us pushing for expedited schedule, is January 2026. And without a reprieve, Oscar will be dead before then. As Oscar's lawyer, I'm here to say that he should not go through this torture a second time until we know that there is a protocol that is constitutional and that TDOC will apply even-handedly and that they will follow. Oscar should not have to prepare to die again knowing that the chemicals that will be used to kill him might not have been handled right, might not be potent enough to do the job, might cause extreme pain when they inject them. He should not have to prepare to die again, knowing that the safeguards our system says are required for such things to be constitutional are not in place. He should not have to prepare to die again until the courts have reviewed this protocol. It is simply unconscionable to bring a man to the edge of execution, admit that you've screwed up and that the rules were not followed, make a new plan, taking away the rules, and then put him to death before a challenge can get to the courts. There have been multiple executions on Governor Lee's watch where he said he was satisfied because the courts had acted, because the courts had spoken. We are asking him here to do as he did before and issue a reprieve so that the court has time to do its job.
Good morning. My name is Rafia Muhammad McCormick. I am the founder of Rodney's Village, and I'm also the creator of the Heal People campaign. I stand here today not only as a mother who lost her son to violence, but as someone who has committed her life to advocating for survivors across Tennessee. 5 years ago, my son was shot and killed during a pool party at my home in Murfreesboro. And since that day, my life has never been the same. But in that pain, I found purpose, and I began walking alongside countless other survivors, many of whom feel forgotten, silenced, or unsupported. I've learned a lot from those conversations. And one thing has been very clear across every story. What survivors need most is not more punishment, but more support. That's why I'm here today to support this letter from Reprieve, calling on Governor Lee to not resume executions in Tennessee. It's shocking and frankly heartbreaking that Tennessee is pouring thousands of taxpayer dollars into purchasing lethal injection drugs, money that could be used to actually help survivors of violent crime. There are so many families struggling right now to bury their loved ones, to afford the counseling they need, or even find space to breathe after that trauma. And yet we're spending thousands of dollars to plan more state-sanctioned deaths. That's not justice. That's injustice compounded. The $500,000 that we just spent to procure those drugs could go an incredibly long way toward helping families like mine rebuild. It could cover funeral expenses, trauma therapy, case management, support groups, and long-term trauma-informed services that actually heal. Executions don't do any of that. The young man that killed my son was not sentenced to death, and that was never what I needed. My son's life could not be restored with his death anyway. What I needed was a path forward, a way to put pieces of my life back together, to take care of my family and to find healing. Tennessee's priorities are deeply, deeply misplaced. We continue to invest in punishment over prevention and death over life. The truth is, every dollar spent on execution is a dollar not spent on a therapist, a support group, a violence interrupter, a caseworker who could walk beside a grieving family. That's what we really need. And that's where our resources should go. That's why I helped create Heal People campaign, a statewide initiative that we have used to travel across Tennessee to host conferences workshops, and forums that educate, uplift, and organize survivors of violence. We're shifting the narrative because we believe the most impacted by violence should be the ones that are leading the solutions. Proudly, I'm so proud that I have founded Rodney's Village, a community-based effort named in honor of my son. We work with young parents to build strong, emotionally intelligent families because we know that families are stable and supported and communities will be safer. That's what prevention looks like. And it's possible when we invest in those types of solutions. We do not need more executions. We need more healing. So I'm asking today, what would it look like if Tennessee chose healing over harm? If we invested in life instead of death? If we directed our energy toward helping families like mine not only survive, but thrive? That's what I'm working to build, and that's why I support the request made by Reprieve. I urge our governor and our state leaders to do the right thing. Do the just thing. Choose healing, choose hope, choose survivors. Thank you.
Good morning, everyone. I am Reverend Stacy Rector. I'm the Executive Director of Tennesseans for Alternatives to the Death Penalty. We are a statewide organization that seeks to honor life by working to end the death penalty, prevent violence, and support those who've experienced harm. I first want to thank Governor Lee for showing true leadership and moral clarity in preventing Tennessee from carrying out unconstitutional executions over the past 5 years. As you've heard expressed earlier, in 2022, the governor stopped executions because of serious concerns about Tennessee's lethal injection protocol, and he ordered an independent investigation to identify and address these concerns. The report that was released upon the investigation's conclusion found the TDOC had failed to follow its own lethal injection protocol, including the failure to properly test the drugs, the failure to provide the compounding pharmacy with the state's own protocol, and the failure to ensure that the drugs had the required potency. The report also notes that TDOC leadership placed an inordinate amount of responsibility on the individual who procured the drugs, and I quote from the report, without providing much, if any, professional guidance, resources, or assistance. Instead, TODC leadership viewed the lethal injection process through a tunnel vision, result-oriented lens, rather than provide TDOC staff with the necessary guidance and counsel needed to ensure that Tennessee's lethal injection protocol was thorough, consistent, and followed, unquote. Following the report's release, Governor Lee renewed his commitment to continued transparency for the people of Tennessee and ordered decisive action to address the problematic findings. Unfortunately, the newly adopted protocol does not give Governor Lee what he asked for. In fact, the new protocol is less transparent, less detailed, and less consistent, even going so far as to authorize the state to deviate from its own protocol whenever the commissioner deems it necessary. This new protocol is supposed to act as Tennessee's own official set of rules governing the execution process. And Governor Lee himself has stated he wants to ensure the department adheres to the established protocol. By its very nature, then, the established protocol cannot be open to deviation on a whim. If it can, why have a protocol at all? Governor Lee, we are here, as you have heard, to urge you to take decisive action again to pause all executions in Tennessee, to allow time for judicial review of this new protocol. We must not repeat past mistakes that only cause unnecessary harm to everyone involved, including the correctional staff, including the inmate's family, including the victim's family, including the attorneys, including everyone that this process touches. It is essential that the courts are not rushed in their deliberations so that we can trust our state's actions are constitutional and are accountable to us, the people of Tennessee. Thank you.
Once again, good morning, and thank you for being here today. My name is Reverend Dr. Kevin Riggs, R-I-G-G-S, and I pastor Franklin Community Church in Franklin, Tennessee. Our church has an extensive ministry inside Unit 2 at Riverbend Maximum Security Institution, also known as Death Row. I personally visit Unit 2 on a regular basis and consider all the men in Unit 2 as my friends. Several of the 9 men who have signed on for this lawsuit would consider me at least one of their spiritual advisors. I'm here today to stand in solidarity with the 9 men who filed this lawsuit and to support the request of reprieve to give the court time to review the new execution protocol. I'm going to take a little bit of a different turn than those before me to talk about an aspect of the new protocol that could be overlooked, but we need to bring attention to it. The part of the protocol that concerns me is the part that states that a prisoner will not have access to his spiritual advisor for the last 12 hours leading up to execution. This prohibition denies the prisoner his religious rights as well as violates the spiritual advisor's religious freedom to minister as he or she determines that God has allowed them to minister. The Supreme Court of the United States ruled in March of 2022 that federal law gives prisoners facing execution the right to have a spiritual advisor in the death chamber with them at the time of execution, and that spiritual advisor can not only be in there with them, but that the spiritual advisor can touch the person as they're being executed and audibly pray over the person as they're being executed. Recognizing the Supreme Court's decision, Tennessee's new protocol does allow clergy to be in the death chamber with the inmate. The prohibition they put in place is that the 12 hours leading up to the execution, the spiritual advisor cannot be with them. That makes no sense to me. If I can be in the death chamber with the person as they're being executed, why can I not be with them up until the time they're executed? Why prohibit myself or any other spiritual advisor from being with the person during that 12 hours leading up to it? If the spiritual advisor can be with the prisoner at the time of execution, that spiritual advisor should be allowed to stay with the prisoner for all the time leading up to the moment of execution. And I'm not a lawyer, but I would think that that was implied in the Supreme Court's decision that the spiritual advisor could remain with the condemned person the entire time. In the independent investigation ordered by Governor Lee after the failed execution in 2022, there were no findings, accusations, or conclusions that spiritual advisors were the problem in the execution protocol. Spiritual advisors have never interfered with the execution process and have always ministered with grace, mercy, and integrity. To allow them not to do so for a 12-hour period of time seems to me to be arbitrary and unethical. The only reason I can think of for not allowing the spiritual advisor to be with the prisoner for this 12 hours leading up to death is to cause more pain and trauma on the condemned. There is no justifiable reason to prohibit spiritual advisors from carrying out their ministry at any time during the entire execution process. One of the signers of the lawsuit and one of the men awaiting an execution date is Reverend Kevin Burns. Now, you may ask yourself, well, why is he referred to as Reverend Kevin Burns? Well, that's because my church ordained him on January 29th, 2018, and then we helped him start a church on death row called the Church of Life. And as far as we know, it's the only church on death row anywhere in the country that is led by one of the men serving on death row. I am Kevin Burns' pastor. I mentored Reverend Burns for 2 years during the ordination process and then officiated his ordination service inside Unit 2. And Reverend Burns' first act as an ordained minister was to administer the Lord's Supper to all those in attendance. Now think about that. A week from today is Maundy Thursday, Holy Week. On Maundy Thursday, Jesus, a man condemned to die, administered the Lord's Supper to his disciples. And I'm telling you, since communion has already been brought up, there's something religious and ultra-spiritual about receiving communion from a man condemned to die. But even before Reverend Kevin Burns was ordained, Reverend Burns served as a chaplain's assistant on Unit 2 and ministered to several inmates before they were led away to execution. Reverend Burns is a minister of the gospel and changes the lives of everyone he meets, from other prisoners to guards to administrators and to volunteers. Furthermore, since his ordination, Reverend Burns has become my pastor. I pastor a church, and every pastor needs a pastor. My pastor is Reverend Kevin Burns. The thoughts of Reverend Burns being executed by the state is unimaginable to me. Not being allowed to be with Reverend Burns as his pastor for any amount of time is unthinkable. From the New Testament, we learn the Apostle Paul was executed by the Roman government. And while Paul was in prison awaiting execution, he asked for friends to come and be with him. And Paul writes to Timothy in 2 Timothy 4, verse 11, "Only Luke is with me. Get Mark and bring him with you, because he is helpful to me." It is assumed that both Timothy and Mark went to be with Paul, ministering to him while he awaited execution. We'll wait just a second. It is assumed both Timothy and Mark went to be with Paul, ministering to him while he awaited execution. I like to think that the Apostle Paul spent the last moments of his life surrounded by people who loved him. And so, on behalf of myself and all the other clergy and spiritual advisors who minister on Tennessee's death row, please don't deny us the opportunity to be with the inmates for the duration of the execution process. Governor Lee, please grant a reprieve for the scheduled executions this year to give the courts time to review the new execution protocol.
Thank you all very much for being here. We do apologize about the noise and appreciate you spending your time with us here this morning. We will answer any questions if anyone has them. We have not heard, of course, we just gave him the reprieve letter about 2 hours ago, but we have not heard anything from him, no.
If he follows through with your request, how confident are you, and he decides to wait for the judicial review, how confident are you that you come through that and any positive change or anything that what you guys are asking
if we have the time for judicial review, we are very confident that we will win in the Chancery Court and that the Chancellor will declare this protocol unconstitutional. So the Middlebrooks case, two cases were pending in April of 22, the Terry King case and the Donald Middlebrooks case. They raised similar issues and had at that point been combined for trial that was supposed to occur that August. When the state came to us and asked us to stand down, they wanted us to stand down and so agreed that if there was a new protocol, they would agree to a stay of execution to allow that particular litigation to move forward. Unfortunately, they're not willing to provide that same grace to the other men. So, no, we would have to try to intervene into the federal court litigation, which would take a lot of time, and there's just not time to do that because the state has already said they would oppose any intervention. And because the issues also involve state court issues, we decided Chancery Court was the place to be.
At the beginning of your statement, you took us back to April 2022, and you said that in your heart of hearts that day you knew that the protocol had not been followed and that things weren't right. Can you explain what you meant by your heart of hearts? Does that mean that you consider TDOC in bad faith with regard to executing people on death row?
I'd seen the receipts.
Okay.
I'd seen the discovery in the Terry King litigation that showed that the testing hadn't been done in Donald Johnston's case. And having litigated these issues before, I knew that every other case hinged on the credibility of TDOC employees coming into court and telling the court, we promise we're going to do these things, we promise we're going to implement these safeguards. And the court saying, well, we have to take their word for it. We don't have any proof otherwise. And I knew that they hadn't kept their end of the bargain based on the discovery that I had seen in the Terry King litigation. Again, thank you all so very much. Appreciate you coming out today.